let's start on the actual structures. The public company limited by guarantee is the one that we would ordinarily recommend. I mean, obviously we'd need to talk to you about what you want to achieve, but usual not-for-profit these days. It is a company. It is established under the Corporations Act, which is a Commonwealth law. It's the more usual structure that we would be recommending to somebody who wants to start a not-for-profit now and run activity and, operate and employ staff. It must have one member. It must have 3 directors. It can trade anywhere in Australia, anywhere in the world. So there's no boundaries on it. And it's able to do anything that an individual person can do at law. So it's the shot. So public company, it works on the basis that it's a membership-based organisation, not a shareholding. So if you see all the stuff on telly about shareholders' meetings and the board sits at the front and all the people sit at the back and shout at them, those people are usually shareholders. So those people have usually bought a share in that company, and whatever's happening in the company's balance sheet really makes a difference to the value of their share or the dividend they get. A public company limited by guarantee doesn't have shares. So your members aren't, whilst you can think of them as owners, they're not really owners. So they don't actually can't draw property out of it. They don't get an income out of it. The membership is really to help drive the direction of the company in due course, pick the directors, those that are actually running it each year. So it's very much like an incorporated association in that sense. If you sort of have a club, where you've sort of got all your members and you all go and play sport, and then you pick your exec for the year. It's that sort of thing, but it's different, structured differently under the law. Okay, so members can control who else is a member. So basically your constitution could say only, quite tall, red-headed, freckly women can be members of this company. So you can actually set parameters around that. Or you can just say anybody can be a member. Okay, so it just depends, quite short, medium, tall, redheads with freckly skin might well want to be a member of a company that's worried about sun cancer. Anyway, that's just to give you a silly example of what I'm talking about. You can control who the members are of the company. So if you think that the members' role is to meet each year, so they meet for the annual general meeting, their role is to be reported to. So the directors have to tell them what's happening in the company. They appoint the directors. They remove the directors. So if the directors aren't performing, the members can remove them. The members can change the content of the constitution. So it's the members who have the right to say, well, our purpose has changed, we're going to change that. So that's your membership, and as I say, it must be one, can be as many as you like. The powers of the company are delegated to the directors, so that's your board. So your group of people who sit as a board are the people that make the decisions on an ongoing basis, unless they delegate that to an employee. There must be 3 of those. There don't have to be any qualifications around them, but you can have qualifications around them. You could say they must be a member. They don't have to be a member, but you might make it that they must be a member, so you know they're committed to the objects. You could say we want, at least one financial person. We want one person who's experienced in HR, one person who's experienced in law, for example. But you don't have to put parameters around it. You can. A not-for-profit public company limited by guarantee can remunerate its directors and still be a not-for-profit. So, and that's becoming more and more important in this day and age, particularly in small areas where there's lots of work to be done and not many people to do it, trying to attract people that might work as a director if they get some money compared to some, volunteers who get very spread. Okay, so public company limited by guarantee can be registered as a charity, and yes, there's those things I've already said. Basically, must one remember 3 directors, can be more. Usually you wouldn't want any more than about 7 directors, because just think about meeting dynamics. Okay, it's a not-for-profit, so its income must be applied to further its objects, and if it's wound up, the surplus must go to another not-for-profit. In terms of liability, directors of a public company limited by guarantee are directors of a company. Same as if they were a director of a private company. They've got the same obligations at law as if you were running McDonald's or some great Qantas. The directors have significant responsibilities. Another reason why some of them might want to be remunerated to take on that responsibility. Members' personal liability, so if you're a member of a public company limited by guarantee, your liability is limited to the membership fee, if there is one, so that annual fee that might be the business model to help you pay for the administration. And in addition to that, there's what's called a guarantee amount. So basically the Constitution must, the Corporations Act provides that the Constitution must have a provision which says that upon the winding up of a company, a member must be bound to guarantee an amount towards the debts of the company. That can be $1. It could be $1 million. It all depends on the nature of your organisation. Most charities, not-for-profit social enterprises, put that at about $10. So basically, if it's wound up, you're a member, you contribute $10, and that's it. One of the areas that we do find in community charity organisations is sometimes the difficulty that people face with conflicts of interest. And basically, the directors must always act and make decisions in the best interests of the company of which they're a director, even if they've got interests, which personal or business, that conflict with what's in the best interests of the company. There's rules around that, lots of rules around that, about how you manage that, because obviously conflicts arise all of the time. And the rules sort of depend on the significance of the conflict, and it might well be that the person who's conflicted stays in the room, adds to the discussion but doesn't vote, or leaves the room. And in some cases, even if there's a conflict, that director is entitled, the other directors say, yes, this person can vote, but it must be very on the face of the minutes and how it was dealt with. We also need to understand about its tax. An individual income earner pays tax, and depending on how much you earn, depends on how much tax you pay. A public company limited by guarantee, if it earns profit, pays 30% tax. There are certain not-for-profits that are entitled to income tax exemption. In other words, they don't pay tax. They don't have to lodge tax returns. That means they don't pay capital gains tax. So they don't pay tax. But there's only certain not-for-profits that are entitled to that. So when would you use a public company limited by guarantee? Well, these days, if you're setting up a social enterprise, we would suggest you use a public company limited by guarantee rather than any other structure.